Good afternoon. I would like to call the meeting of the Assembly Committee on Revenue to order. Will the Secretary please call the roll?
Assemblywoman Anderson.
Present.
Assemblywoman Cohen.
Here.
Assemblywoman Considine.
Present.
Assemblywoman Gallant.
Present.
Assemblyman Gray.
Present.
Assemblyman Hafen. Assemblywoman Mosca.
Here.
Assemblyman Wynn.
Here.
Assemblyman O'Neill.
Here.
Assemblyman Orntlicker.
Here.
Assemblywoman Summers Armstrong.
Present.
Chair Backus.
Present.
Thank you. I would like to welcome our audience members here in Carson City and down in Las Vegas, as well as those watching or listening over the internet. If you have not done so already, please mute all of your electronic devices. Persons wishing to testify today, please sign in at the table by the door. Before beginning to testify, please present a business card to the committee secretary and state your name clearly for the record. If you have any handouts for the committee, you should have provided 16 copies for the committee in addition to providing your handout in an electronic format to the committee staff. We have two presentations on the agenda today, but we are going to take these in different order, basically reverse order. With that, I would ask the presenters from the board, actually from the Cannabis Compliance Board, to make their way to the table. And normally I make sure I have this correct, and if I mispronounce your last name, I apologize because it happens to me all the time, but Director Klimas? Great, welcome to the committee, and please begin when you are ready.
Great. Thank you, Chair and members of the committee. My name is Tyler Klimas, Klimas, and I am the Executive Director of the Nevada Cannabis Compliance Board. Joining me here today, I have Deputy Director Michael Miles to my right, Steve Gilbert, Chief of Administration and Licensing to my left for the CCB. Behind me, I'd also like to recognize David Staley, Chief of Investigations, Lisa Figueroa, our ASO. As well, joining us by Zoom is Kara Carnkite, our Chief of Inspections and Audit, and Tiana Bonner, our Public Information Officer. So when you invite the CCB, you get the whole family. We appreciate the opportunity to be here today to give you a little overview of the CCB, our operations, what we do, and then answer any questions that the committee may have for us. So with that, we'll move on to our presentation. We'll start with our first slide. So this is maybe our most important slide. In 2019, the Nevada Legislature set forth the public policy that would ultimately guide our agency in all of our operations. We take this public policy very seriously as it dictates how we perform our duties, our regulatory decisions, and ultimately our core mission and purpose. You'll see here on this slide that the legislature at the time recognized that the continued growth and success of the cannabis industry is dependent upon public confidence and trust, two words that are also very important to the CCB. And that public confidence and trust can only be maintained by strict regulation of all persons, location, practices, associations, and activities related to the operation of cannabis establishments. This is in law. If this language is familiar, it's because it's taken almost verbatim from the same public policy that guides Nevada's gold standard gaming regulation and oversight. The CCB was legislatively designed to model the same regulatory oversight that we have for gaming, but for the cannabis industry, and for the same reasons. You'll see at the top, the next slide, this is our mission statement. It reflects those same principles. The CCB and its responsibilities oversees Nevada's 760 medical and adult use operational licenses. We enforce statutes and regulations that guide the industry, and we focus many of our efforts on what may be our most important responsibility, which is to protect the public health and safety of our many medical patients, adult use consumers, residents, communities, and visitors to our state. Our agency is managed by a 5-member part-time board. It's currently chaired by former Nevada Supreme Court Chief Justice Michael Douglas. We hold monthly board meetings where the board presides over disciplinary matters, licensing approvals, management services agreements, and new or revised regulations, among other things. The CCB prides itself on accountability and transparency, and through our public meetings, we encourage robust public participation and engagement. Our agency has 93 full-time employees, and we have 4 divisions within the agency. administration and licensing, inspections and audit, investigations, and enforcement. Also created alongside the CCB was the Cannabis Advisory Commission, which I chair in my position as Executive Director. The commission is made up of 12 members and is designed to model the Nevada Gaming Policy Committee. So the commission meets at the request of the CCB board, the governor, or the legislature to study cannabis-related issues when they come up and make recommendations to the board. The most recent example of the CAC's work took place over the last 2 years as it studied the implementation of consumption lounges. When the CCB came online and was first authorized in July of 2020, we had 50 full-time employees. Since then, our agency has continued to grow now into the 93 full-time staff currently authorized. Along the way, we've identified many operational efficiencies and addressed many issues that plagued the previous oversight body, working to automate much of what we do, and through reconfiguration of resources and functions, work through all of the backlogs we inherited or that were created as a result of the transfer of oversight responsibilities. This slide gives you a snapshot of our distribution of licenses statewide, as well as some other facts on license holders, agent cards, and the types of facilities that we regulate. That includes cultivation, production, laboratories, distribution, retail dispensaries, and now, or soon to be, consumption lounges. You'll see we have over 18,000 active cannabis agent registration card holders in the state. The state of Nevada allows cannabis licensees to be structured in two different ways. You can have a standalone business or you can have a vertically integrated operation. That is, you as a licensee can own just a cultivation facility or just a production facility or just a dispensary. Or you can own all three and control your own supply and sell your own product, as well as purchase products from other establishments. We call that being vertically integrated. A licensee can also own any combination of those licenses. The only license you cannot own if you own either a cultivation, production, or distribution or retail store is a laboratory. Laboratories must remain independent and no shared ownership is allowed. These structures will be important when you talk with taxation next about fair market value determinations. The taxes that are collected by the Department of Taxation relating to cannabis include a wholesale tax and a retail tax. The wholesale tax is a 15% excise tax levied on the first arm's length transaction of cannabis at the wholesale level. So that's before it moves to a retail facility, and is taxed on the price the Department of Taxation determines to be the fair market value of that product type at that time. The other tax is a 10% retail tax collected on the retail sale of cannabis products at adult use retail stores and dispensaries. Some information on taxable sales and tax collection. You'll see information and sales data spanning the last 3 fiscal years. This is the first year since cannabis was legalized in Nevada for adult use that we've seen a decline in yearly sales. We're down about 4.5% fiscal year over fiscal year and about 14.5% calendar year to calendar year. This trend is consistent with more mature cannabis marketplaces across the nation and is a result of a number of market dynamics. For one, we had been experiencing extreme year-over-year growth since 2018 when we legalized adult use. The numbers were always going to stabilize at some point and lend to a baseline, and then the pandemic hit. People were at home, people received stimulus money and had sizable discretionary income, and we saw almost a 50% increase in sales from fiscal year 20 to fiscal year 21. So now we are finally coming back to earth a little bit. The pandemic restrictions are ending, people are back at work, discretionary income is falling as inflation continues to affect our economy. We have competition from the illicit market. And again, what we're seeing in Nevada is consistent with what our counterparts are seeing in other states. If anything, given our tourism economy, our prices have not fallen as much as some of the other states, at least so far. Our agency is funded a little uniquely. We do not take any general fund money. We are fee and tax funded, with the remainder of what is deposited into our account transferred to the state education fund. As you can see, this past fiscal year, we generated just over $8 million in licensing fees, time and effort assessments, agent registration fees, and fines and civil penalties. There was also just over $63 million collected from the 15% wholesale tax. That wholesale tax money is then combined with our agency-generated revenue, and from there, we take care of our operations. We send $5 million to local governments. We send $250,000 to the health division, and then transfer the remaining balance to the state education fund. This fiscal year, it resulted in just under $59 million transferred to the SEF. Now, as discussed prior, that $59 million is not the only revenue stream from cannabis that flows to the education fund. There is also that 10% retail tax on cannabis sales at the retail level. That amount also goes into the state education fund in its entirety, but does not pass through the CCB. In the most recent fiscal year, the state collected over $89 million from that retail tax. So that number plus the $59 million we sent resulted in a combined $147 million transfer to the state education fund for fiscal year '22. And again, to note, you'll hear from them soon, but the CCB does not handle tax collection on the wholesale or retail side. That duty is the responsibility of the Department of Taxation. Next, I'll highlight our 4 divisions briefly to give you an idea of our operations. The first division is administration and licensing. Admin maintains our database of all license holders and ownership records. It processes and reviews all license applications and renewals and collects all related fees. The division is also in charge of managing the Cannabis Agent Registration Card program, which through the efforts of the Admin and Licensing Division has seen a reduction in wait time for agent cards by 98%. Processing new cards for industry employees in the industry used to take 45 days and now takes 1 business day. Admin also works closely with the Department of Public Safety and the FBI on agent card background checks, as well as with the Department of Taxation on collecting unpaid taxes and fees. I did want to touch briefly on how we enforce or ensure taxes are paid to the state and our regulatory authority. We do have regulatory and enforcement power to ensure taxes are paid to the state by our cannabis licensees, along with the regulatory authority to discipline licensees over unpaid taxes. When we took over oversight of the cannabis industry in mid-2020, we identified a number of outstanding tax bills, and through further investigations found instances of unfiled taxes, incorrectly filed taxes, non-payment of licensing fees, and non-payment of time and effort assessments. It was a little bit of a mess. As a result, the board, as one of its first initiatives, was to make it clear to the industry that this isn't going to go on any further. This is a privileged industry, and you'll need to pay your taxes, and you'll need to file and pay them on time. We passed necessary regulations that made it clear that licensees do need to comply with the tax requirements or risk losing their license. What we also did was implement a change to our yearly renewal process that essentially required you to be up to date on all outstanding taxes, renewal fees, or outstanding invoices, or you would not be able to renew that license. Pretty straightforward. We also worked with the Department of Taxation to utilize a process they already had in place for Nevada taxpayers, in which a licensee would need to provide appropriate documentation that showed they were in compliance with tax requirements. And as you can imagine, given that you certainly can't grow or sell cannabis without a license, we began to see many of those outstanding payments become paid in full. Since then, outside of some one-off issues, we see very few instances of tax noncompliance outside of business restructuring or payment plans entered with the Department of Taxation. Additionally, through enforcement efforts and some of our larger disciplinary actions over the last 2 years, we've been able to recoup in full large outstanding tax balances due to the state due to unfiled taxes and tax avoidance. Although we will not be able to fully quantify that exact number, all of these efforts have resulted in capturing millions of dollars in owed tax revenues to the state. And I have to compliment our friends at the Department of Taxation, who has always been a great partner in these efforts and continues to be today. Our agencies, without a doubt, must have a strong working relationship in this area, and we do. Recently, we successfully facilitated the first licensing round for consumption lounges in Nevada. This was a significant accomplishment for the CCB and the state because there had not been a licensing round in Nevada since 2018, which, if you remember, was highly litigated, is still going on in the courts, and nearly brought this industry to a standstill. We implemented a random selection process for this round, which allowed us to hold a randomized drawing for licenses at a public event to ensure total accountability and transparency of the licensing round. The round was also the first time that the state has allowed for individuals who were not already in the industry to apply for a cannabis license. Up until this point, all licensing rounds prior applied only to those who had already had cannabis establishments. Furthermore, the licensing round facilitated Nevada's first ever social equity licenses. This was a component of Assembly Bill 341 from last session. 10 lounge licenses were available only to those individuals who were deemed to have been negatively impacted by prior drug policy. This is the first step and a very significant step towards greater equity and inclusion in the cannabis industry in our state. The Inspections and Audit Division agents visit all Nevada's cannabis licensees at least once a year, and in many cases more than that, to perform routine audits of inventory and inspections of facilities. Inspection and audit agents also conduct pre-opening inspections, facility modifications, and spot checks, usually around major holidays and events. CCB and inspection and audit agents ensure facilities and establishments remain in compliance with rules and regulations. They track all inventory from facilities through Metric, which is our seed-to-sale tracking system, and they also inspect Nevada's 10 testing laboratories to ensure laboratory standards and appropriate procedures are being followed. When our agents finish an audit or inspection, they either issue a statement of deficiency or a statement of no deficiencies, depending on the result of the inspection or audit. As you can see, in calendar year 2022, out of 427 notices issued, we had about 56% receive statements of deficiencies, which means we identified violations or instances of noncompliance, and 44% received statement of no deficiencies, which means it was a clean audit or inspection with no compliance issues found. So roughly half of our inspections and audits in a given calendar year have no compliance issues to report on. That's a good thing. We would like to see that number grow. Now, just because you receive a statement of deficiency does not mean you'll be fined or a complaint will be filed. Many times these are minor deficiencies that can be corrected by submitting back to the CCB agents a plan of correction which we review and approve. When a violation does rise to the level of potential disciplinary action, we transmit the details of that alleged violation to the Attorney General's office, who reviews the case and recommends back to us either to proceed with a complaint for disciplinary action or not. Only at that point, and if the Attorney General's office agrees with our recommendation, do we then proceed with disciplinary action. As you can see, there were 23 complaints authorized by CCB board members in 2022 as a result of violations identified. So we had 427 audit and inspection notices in 2022, and the board authorized 23 complaints. Recently, and of note, the CCB introduced what we call letters of concern, providing our agency with a tool that sits somewhere in between a statement of deficiency and a complaint. It allows us to issue an official letter in lieu of a disciplinary complaint. It serves as sort of an informal warning and doesn't come with a complaint or financial penalty. This process has allowed us to provide an extra layer of education with the industry to address a violation before such conduct escalates to a disciplinary complaint. Additionally, the CCB and the Attorney General's office take into account self-reporting as a mitigating factor in our disciplinary process. These mitigating factors are usually noted in any settlement agreement and presented as part of that settlement agreement to the board before the board approves any final action. These settlement agreements are also posted online for the public to view. Now, we receive hundreds of self-reporting incidents every year, and multiple on a daily basis. Most don't rise to a disciplinary level, especially if the licensees take immediate action. In fact, there's only been a few cases, exactly 5 cases in our history as an agency, so in 2.5 years, that a self-reporting violation did result in a disciplinary action and financial penalty. Those cases, however, dealt with subject matter that this board, along with the United States Department of Justice, consider to be the most important pillars of keeping a safe and successful industry that remains free from any potential federal intervention. That includes sales to a minor, diversion of cannabis out of a facility, and hidden ownership, which has potential to invite criminal elements into our industry. 3 of the 5 self-reporting incidents that have resulted in a fine dealt with one of those topics and carried a significant financial penalty as a result. The other 2 dealt with selling more product than what is allowed to a single consumer in a transaction. And although we consider that a serious issue, they were subsequently pled down to a financial penalty significantly lower than what could have been assessed. Again, all of these actions are decided at a public meeting, are totally transparent, and are posted online for anybody to view. Moving on to our investigations division, our investigators are tasked with processing all transfers of interest. So these are sales of licenses to new owners, or if a licensee sells a percentage of ownership to new or existing owners. This process includes a complete vetting of all potential new licensees and affiliated owners, officers, and board members. It includes sit-down interviews with applicants and a full suite of background checks and financial analysis on potential entrants into our industry. This process was modeled after how the Gaming Control Board vets potential licensees in the gaming industry. The CCB Investigations Division has been a large success, especially in efforts to uncover hidden ownership and to ensure we know exactly who is in our cannabis industry. The results of these investigations are presented in public to the board, and potential and current licensees must appear in front of the board to answer questions about the vetted transaction. CCB agents have uncovered a number of instances of hidden ownership within the industry, along with potential bad actors and individuals unsuitable to participate in our industry. Finally, the CCB's small but mighty enforcement division is made up of 8 post-certified enforcement officers. In addition to supporting complicated and/or contentious facility inspections, our enforcement agents investigate criminal complaints as well as participate in multi-agency law enforcement actions to address illicit market activity like outdoor cultivation sites and illegal sales of cannabis. The CCB hosts quarterly law enforcement meetings where we invite all local, state, and federal law enforcement agencies in a closed-door meeting to discuss cannabis-related issues and share operational opportunities and challenges. And that completes the rundown of the CCB's 4 divisions. The next slide, this legislative session, we have 3 bills that we are carrying. They deal mostly with housekeeping issues and some license transferability issues. We're happy to answer any questions on these after the presentation. The next slide, and this is some additional thoughts to consider, some challenges that we see this year. As discussed, sales are down and tax revenue is down. Federal inaction on cannabis-related matters continues to hamper both regulators and the industry. Limited access to banking keeps the industry, or at least a percentage of the industry, all cash-based. Federal tax code continues to prohibit certain tax write-offs for cannabis businesses, which increased overhead costs, places an additional economic strain on these businesses. And additionally, there remains this constant threat or possibility of federal action to reschedule or legalize cannabis at the federal level. We know it's coming at some point, we just don't know when. However, that would significantly change or alter the marketplace here in Nevada if it did happen. Finally, the illicit market continues to be a major issue here in Nevada, as it is in all other states which have a legalized cannabis marketplace. It is the #1 competitor to our legal market and licensees. It puts unsafe product on the streets, and the state misses out on tax revenue as a result. So looking ahead, we'll start to see consumption lounges open, likely towards the end of this year and into next year. We are also commissioning a market study that will review and analyze our cannabis marketplace, including examining supply and demand, any need for new licenses of all licenses, as well as analyze the breadth and scope of the illicit cannabis market in our state. So with that, and I appreciate some of the committee who heard this exact presentation yesterday, we are here to answer any questions that you may have. Back to you, Chair. Thank you.
Thank you so much, Executive Director Klimas. We do have some questions. We'll start with Assemblywoman Natha Anderson.
Thank you, Chair, and thank you for the presentation. This is the first time I got to see it. I was not in the morning committee. So I have 2 questions. The first comes from, I believe, about slide 10, when, although it's not on the slide, you had mentioned that based upon the administration and licensing and the need for back research, that there's been millions of back funds that have been captured. Are those funds then put into the cannabis area so then they can go into education as well as general funds, or do they go into a different area of our tax department?
Thank you, Assemblywoman, for the question. Depending on if they were outstanding wholesale tax or retail tax, either way, they go to the State Education Fund. They go into the same bucket. Wholesale flows through the CCB. Retail would flow through the Department of Taxation.
It's not me. No, I'm just kidding. It's the user. Can I ask a second question? Thank you. My second question actually comes from, I believe, around slide 16. I was kind of trying to follow along as well as looking at the staffing agency growth and all those items. It had to do with, you mentioned that there are bad actors that are caught and then they are reported to the board. Does the board make the decision as to what to happen with that application? Does it go forward without those names on there? Is there a list of them? Are they put into are they cannabis jail? What happens to them basically to make sure that they do not attempt a second time to come forward?
Sure, and that's a great question. So yes, everything is open and transparent and happens at these board meetings. So they're called transfers of interest. And so if the board has concerns, they usually start at the staff level. Investigation staff will prepare a investigative report, 20 to 30 pages on this proposed transaction. That report goes to board members before the board meeting. They have that information, and then they're able to ask further questions. And then at that point, they have the ability to accept or approve the transaction, deny the transaction, send the transaction back to staff, direct licensees to provide further clarity, whatever they decide. But yes, they have that power to either approve or deny. It's a privileged industry here in the state.
And my last follow-up, I promise, Chair, if I may. Thank you. So with that, does the staff make a recommendation, though, as to whether to approve or disapprove, or is that completely up to the board? And then also, looking over your biennial report, as of December 2022, you have a 15% vacancy. How many of that staff is actually the investigative individuals? So they're kind of not related, I'll admit it.
Well, our chief of investigations behind me will be happy that I can report that there are no vacancies on the investigations team currently. So that answers your second question. And your first question is, yes, so staff may recommend denial, approval. Staff can recommend the board question further on an item. So it's really open. And at the end, though, it is up to the board on how they proceed.
Thank you. Our next question, let me go with Assemblywoman Gallant.
Thank you. Hi again. Nice to see you. I'm curious, is there a schedule of fees, fines, licensing? Is that clear when a business opens and continues to operate? And then also in terms of the transparencies of the fines, fees, what about the schedules of inspections? Is it just like a pop-in, or is that scheduled as well so that a facility can prepare? And again, I'm more asking this question in terms of like the good actors, like bad actors are going to be bad actors. But in terms of those operations that are running like good, solid businesses, what is the level of transparency on their interactions with you?
Assemblywoman, thank you for the question. Tyler Klimas for the record. So for your first question, yes, so we go by category fines. And so there's different categories, category 1, 2, 3, 4, and 5. Those are listed in the regulations, as well as any kind of violation that would fall in that category and max penalties that are included in there. So all that is listed in the regulations and is very clear. And that's what our attorneys and our process go through when we create the complaint. And then if it ends up in a settlement or hearing, that's what we go by. So that is clear. Your second question on inspections and audits, they are not scheduled if they are routine. So our routine inspection and audits are unannounced, and we go to the facilities or visit the facilities at least once a year. Now, there are different times where we may schedule an inspection or audit. Let's say you're making a modification to your facility. Let's say that you are having a pre-opening inspection before you open. We'll schedule that. Sometimes facilities can reach out to us and say, would you please come and do an inspection? We've reconfigured our inventory program or tracking, and we would like to make sure that it's going to be in compliance. Can you come out? And we will also do that. So it just depends. But the routine annual audits and inspections are unannounced.
Thank you. Next, we will go with Assemblywoman Mosca.
Thank you, Chair, and thank you so much. Just a quick question. Do the wholesale tax and the retail tax apply to the lounges?
Thank you for the question, Assemblywoman. So they will not participate in any kind of wholesale cultivation or production. So the wholesale tax will not. However, the retail tax will apply to consumption lounges at the point of sale.
Next, we'll go to Assemblyman Gray.
Thank you, Madam Chair. So I'm going to get down into the weeds on this one a little bit. You did. You did. Sorry. No smoke screens, though. But I stole those out of his playbook yesterday. Sorry. So with regards to banking and paying taxes, how's that working now with the banking regulations still being what they are, and how are they transmitting that money to the state? Just wondering, it's just something that's been in the back of my mind, how we're working around that.
Thank you, Assemblyman, for the question. And if I think of a better pun, I'll come back at you with that. But, you know, I mean, it's a huge pain point, remains a huge pain point. I don't think we're as cash-based as we used to be, you know, with the large bags of cash being transferred to state offices. It still happens. I mean, the Department of Taxation behind me will probably tell you that it does. So people still pay in cash. I think a lot of our licensees are finding banking partners now where they didn't, but they're getting just crushed on fees. They're going out of state for banking, and they're just paying an exorbitant amount of fees, and that's consistent, you know, nationwide. And that's going to remain until Congress passes some kind of banking legislation, which, you know, has passed the House a number of times and is ready to go, but it just hasn't crossed that finish line.
Next, we'll go on to Vice Chair Considine.
Thank you, Madam Chair. I have two questions, but I'll just ask the one. I was at the other hearing, and what was brought up was a question about if you can explain what Delta 8 is, and also explain the difference between CBD and cannabis and why they're completely regulated differently. Thank you.
And this is where I phone in on Zoom. Thank you, Assemblywoman, for the question, to Kara Cronkite. She's our Chief of Inspections and Audit. So if there she is, if Chief Cronkite could jump in, that'd be great.
Yeah, hi, I'm Kara Cronkite, Cronkhite. Delta 8 THC is really like Delta 9 THC. That's the main component in cannabis that is psychoactive. It's the part of cannabis that makes you feel high. Delta 8 is just a synthetic version that is made where the double bond is on the 8th carbon instead of the 9th carbon, hence the name. So the structure of the chemical is really almost identical. It looks the same, and it has very similar effects on the user. There are several reports of Delta 8 THC making people feel ill. The way that Delta 8 THC is made, it's not naturally found in cannabis to a measurable extent, if it is at all. And so what people will do is they'll take CBD, which is a non-psychotropic compound. It doesn't make you high. It's a cannabinoid that comes from hemp and cannabis plants. And they'll take that CBD and they'll mix it with an acid catalyst. And then that turns the CBD into Delta 8 THC. And all these structures are chemically very similar. And that's how that's able to happen. The problem with that is we don't really know what the byproducts are from that. And so it could be potentially very dangerous. We do in Nevada, we do not allow synthetic cannabinoids to be made unless the CCB has approved the process. To date, we have not yet approved any such processes. So you shouldn't really be seeing that in cannabis. And the difference between, I think the second part of your question was the difference between CBD and hemp products versus like cannabis and Delta 9 THC products. Cannabis is grown to have those psychotropic effects where the user feels high, whereas hemp should not. It should be less than 0.3% THC. And in Nevada, we've defined THC to include all those different synthetic or non-synthetic isomers of THC. So Delta 8 is captured in that limit. And if I missed anything, I apologize. I'm still available for more questions.
Thank you so much. Next, we will go to Assemblyman Haven.
Thank you, Madam Chair. And thank you guys for being here today. I kind of want to touch a little bit on your market study and how that is going to really look at more of the illicit and illegal market. My understanding is that that's becoming a bigger and bigger problem, and it's very difficult for law enforcement to determine where the product's coming from. So I'm very happy to see that you guys are going to be doing the market study. Kind of like to know more, and is that going to be bringing forward legislation in 2025, or is it something we could is there something we could do now to try to help crack down and help your agency, control the unregulated portion?
Assemblyman, thank you for the question. Tyler Klimas for the record. And so, the way we look at this, and you're absolutely right, this is a significant issue. It's happening all across the country. When we legalized cannabis marketplaces across the states, we kind of had this thought, I think, collectively, in hindsight's 2020, that a legal market would just stamp out the illicit market. Why would you go to the illicit market if you go to the legal market? We know now that didn't happen. If anything, in some instances, the illicit market has continued to thrive and continues to grow. What we don't know is how big it is. And states are having a very difficult time trying to figure out exactly how big is the illicit market in their states, how much market share is it capturing. You hear 40%, 60%, 70%. I think Massachusetts said it was 80%, which is a huge number when they do over $1.5 billion in sales, right? Which I'm probably off on that number, but just for context. So, in its most simple, method, you take, how much is consumed in the state, and you back out how much is legally sold, and the remainder is how much is sold on the illicit market. And so that's what you would want a market study to find out, so we know where it is, and then we can start to measure if we're effective in our efforts or not. Nevada's going to be a little bit interesting because of our tourism dollars, so we've got a lot of people coming in from out of state and buying product here. So that's the extra element, which is why I think it's important that we go outside through an RFP to try to get an organization or a company to come in and do a deep dive and analysis on that. We'll end up doing the RFP process, which is out there right now. We'll come to IFC and ask for the funds once we know exactly, or we've identified a company that we want to perform that. Other states have done market studies as well. We just haven't done one. And then that's kind of our first step to start to measure the effectiveness. It could end up in legislation for 2025. I believe it's going to be a topic we'll continue to discuss this legislative session, and it's certainly not going away. And you're right. We need resources all across the board. And these quarterly meetings that we've put together on law enforcement have been very, very helpful for at least all of us to be talking, all the locals, all the states, and even the feds. And so we're prepared to start addressing that, but we certainly need to do that.
Thank you, and I appreciate that, because I do see that this is a problem not only for the industry and your agency, but for the individuals that are consuming the product. Nevada has historically had the gold standard for testing, and to ensure that the product is of quality, and so that our consumers don't have issues with it. And so I have some serious concerns from the health perspective of what is going on the illegal market and what people are actually consuming. And so anything that your board can bring forward to help us crack down on that, I know I look forward to hearing that, and I do look forward to seeing the market study, even if it is coming through IFC. So, but the sooner the better. Thank you, Madam Chair.
Assemblywoman Summers Armstrong.
Thank you, Madam Chair. Thank you, gentlemen, for the presentation. We hear so many rumors as we are going through this process. One of the things I would really like to know is I received assertions that owners are related to cartels, and that those ownerships may be feeding into purported increases in human trafficking in the resort corridor. Have you all done any research on this, any investigations, and can you confirm any of these rumors?
Assemblywoman, thank you for the question, and I can tell you, Tyler Klimas, for the record, that we share your same concerns. And that's one of the reasons that we put together our investigations division. This was probably the largest departure from the past oversight body, was creating an investigations division. We pulled resources from the Gaming Control Board and created this group. And as I mentioned before, we model, our vetting process is modeled after Gaming Control Board's vetting process. And so you know, in 2.5 years, we've found instances of folks that should not be in this industry. We've found loans from folks that have questionable ties to licensees, and we continue to methodically go through these transactions one by one, licensee by licensee, with our investigations division. We've recently implemented, outside of just the normal investigations, a monitoring function. In our governor-approved budget, you'll notice that there's 3 additional investigation agents. A large part of the reason for that is to continue with this monitoring function. So that is meant to be an ongoing, outside of a particular transfer or transaction. It's a continual monitoring of our licensees to make sure that we know what's going on.
Thank you. Thank you, Executive Director Klimas and your team who have traveled up here to testify tonight, as well as those that are appearing remotely. And with that, we'll close your presentation. Thank you so much. Our second item on the agenda today is a presentation by the Department of Taxation. I would ask the presenters from the department to make their way up to the table. And I would just like to thank Director Hughes for being accommodating with the switch of presentations this evening. Thank you.
Good afternoon, Madam Chair and members of the committee. For the record, my name is Shelley Hughes, Executive Director for the Nevada Department of Taxation. With me, I have Yvonne Navarez-Goodson, who is our Chief Deputy, Jennifer Roebuck, who's our Deputy Director of Compliance, and Jeff Mitchell, our Deputy Director of Excise and Local Government Services. Thank you for allowing us to present a high-level overview of the department and the tax types we administer. You will likely see the 4 of us at your committee hearings throughout the session, and we will be available to answer any tax questions you may have on the tax types we administer. As Director Klimas mentioned, I want to say thank you to Director Klimas and his team, and as Director Klimas mentioned, CCB is not involved in the collection of cannabis taxes, but Director Klimas did a great job explaining the taxation process. So here's the agenda for our presentation today. First, we will begin with a brief agency overview. Next, we will give you information regarding our fiscal year 2022 tax revenue and distributions. Under item number 3, we'll go through our major general fund tax types, which include sales and use tax, modified business tax, commerce tax, insurance premium tax, live entertainment tax, real property transfer tax, and net proceeds of mineral tax. Then we will conclude with a discussion on our remaining tax types that are listed here under number 4. As an overview of the department's operations, we perform a variety of functions, including administering 21 different tax types, including 3 fees. We appraise property, we establish guidelines for local governments, and we ensure compliance with those guidelines. We review local government budgets, and we certify annual populations. Additionally, the department is one of the main revenue collection agencies in the state, and we collect over 70% of the total unrestricted state general fund. In addition to the state general fund, the department also distributes revenue to other sources, including the state education fund and local governments. For fiscal year 2022, we collected and distributed over $9.5 billion in state and local government revenue. This is an increase of over $1.6 billion from fiscal year 2021. The The department's mission is to provide fair, efficient, and effective administration of our tax programs, and our philosophy is to provide consistent, impartial, and courteous service and treatment to our taxpayers. Our mission and philosophy are what drive the work we do, and the department continually strives to fulfill these objectives. At the beginning of the last legislative session, the department's executive team developed a strategic plan, which includes the department's goals listed on this slide. Our strategic plan is available on our website. In our strategic plan, you will find our goals with specific action steps, measurements, and benefits. Though I won't read these goals in their entirety, I will briefly summarize them. Goal 1 is to provide uniformity and increase accessibility for our taxpayers on tax law, policy, and procedures. Goal 2 is to provide education and communication to our taxpayers. Goal 3 is to provide timely, relevant, and accurate reporting. Goal 4 is to attract and retain engaged and an empowered workforce. Goal 5 is to create a modern digital workplace. And Goal 6 is to reduce IT backlog and increase efficiencies. Listed on this slide is the members of the Department of Taxation's executive team, a few of which are here to present today. The Department of Taxation is comprised of 6 divisions and serves as staff to 5 boards and commissions. We currently have 413 positions within these 6 divisions. The Nevada Tax Commission is head of the department and is one of the boards and commissions that is staffed by the department. The Nevada Tax Commission meets multiple times a year to hear appeals, review and hold public hearings on regulations, and pursue other such actions that are necessary for the operation of the Department of Taxation. This is our contact information, and on this slide we have our website address, call center number, and contact information for each of our 3 offices. This slide demonstrates how much revenue we received in fiscal year 2022 from each tax type we administer. As you can see from this chart, of the $9.5 billion in revenue collected during fiscal year 22, sales and use tax collections made up $6.6 billion, or 69.4% of the $9.5 billion collected. This slide also demonstrates our distributions for fiscal year 22. The state general fund receives 40% of our total distributions, or approximately $3.9 billion. Local governments receive 33.5%, or approximately $3.2 billion. And the state education fund gets 24.6%, or approximately $2.3 billion. This slide provides the gross revenue that we receive from each tax type we administered in both fiscal year 21 and fiscal year 22. You can see that we had an increase of approximately $1.6 million from fiscal year 21 to fiscal year 22, which represents a 20.49% change from one fiscal year to the next. This slide breaks down total departmental distributions in fiscal year 2022. The first column provides the amount of revenue that was distributed to the state general fund from each tax type. The second column reveals the amount of revenue that was distributed to the state education fund from each tax type. The third column represents the amount of revenue that was distributed to local governments from each tax type. The fourth column represents revenue that was distributed to other accounts from each tax type. So for example, annually we distribute $150,000 from revenue received from the live entertainment tax to the Nevada Arts Council. And this would be found in this column here. These other distributions are provided for in statute, and we will discuss them in further detail during our discussion of the various tax types we administer later in this presentation. The fifth column represents revenue that was distributed to the state debt service fund from each tax type, and then the sixth and last column represents the total amount of revenue distributed from each tax type. This is a list of some of the major legislation passed from the 2021 session that impacted the department. SB 389 established provisions governing the licensing and operation of a peer-to-peer car sharing program and requires the charging and collection of certain fees when a passenger car is shared through a peer-to-peer car sharing program. For those of you who are not familiar with a peer-to-peer car sharing program, it's a business connecting vehicle owners with vehicle drivers to share vehicles in exchange for money. In other words, an owner of a vehicle uses the peer-to-peer platform to list its vehicle for sharing. A person wishing to use that vehicle will connect on that platform with the owner, pay the required fees, and is given the ability or authority to drive the vehicle for a certain period. The state fee for all shared vehicles is 10%, and for any shared vehicle in Clark or Washoe County, there's an additional 2% fee. These fees are similar to the governmental service fees paid by short-term rental companies. AB 495 provides for the imposition, administration, and payment of excise tax on the Nevada gross revenue of business entities engaged in the business of extracting gold or silver in Nevada. All business entities engaged in the business of extracting gold, silver, or both in Nevada and whose Nevada gross revenue exceeds $20 million during the taxable year must file a gold and silver excise tax return, unless otherwise exempted. Beginning July 1st, 2023, payments made pursuant to the gold and silver mining tax will be deposited in the State Education Fund. SB 440 amended NRS 372.7821 and related statutes to provide an exemption from Nevada sales tax on the sales of tangible personal property to certain Nevada National Guard members and their qualifying dependents living at the same physical address in Nevada. The period of tax exemption is on the day Nevada Day is observed and the Saturday and Sunday immediately following. Members of the National Guard are required to apply for a letter of exemption with the department 30 days before the date in which Nevada Day is observed. If eligible, the department will issue a letter of exemption. The bill requires that when the National Guard member or qualified dependent makes a retail purchase during the sales tax holiday, that letter of exemption is provided to the vendor. The vendor is then authorized to sell to the member or qualified dependent without imposing sales tax on the sale. The vendor is required to retain a copy of the letter of exemption for audit purposes. After this bill became effective, it was determined that the bill violated the Streamlined Sales and Use Tax Agreement. Nevada is a member of the Streamlined Sales and Use Tax Governing Board and was sanctioned for violating the agreement. We have worked very closely with the Governing Board to remedy the situation, and the department will be bringing Senate Bill 50 this legislative session to correct the violation. To give you some background on the Streamlined Sales and Use Tax Agreement, or SUTA, as you often will hear it called, SUTA was developed over the course of several years through the joint effort of over 40 states participating in the Streamlined Sales and Use Tax Project. Nevada became a full member of the Streamlined Sales Tax Governing Board on April 1st, 2008. SUTA's website indicates that the purpose of SUTA is to simplify and modernize the administration of sales and use tax laws of the member states in order to facilitate multi-state tax administration and reduce the burden of compliance. SUTA minimizes costs and administrative burdens on retailers that collect sales tax, particularly retailers operating in multiple states. It encourages remote sellers selling over the internet and by mail order to collect tax on sales to customers living in the streamlined member states. It levels the playing field so that local brick and mortar stores and remote sellers operate under the same rules. SUTA ensures that all retailers can conduct their business in a fair and level competitive environment. SUTA does not override state laws. However, states must comply with the requirements contained in SUTA to be a member state. SUTA applies to the state and local sales and use tax collected by retailers. Chapter 360B in the NRS contains provisions for the implementation of SUTA. Today, 23 states are full members of SUTA. Now we will get into an overview of our major general fund tax types. On Tuesday, Ms. Powers provided the committee with a comprehensive overview of many of the tax types we administer, so we'll try to keep our discussions brief. So I'll now turn the presentation over to Jennifer Roebuck, Deputy Director of Compliance, to begin.
Thank you, Director Hughes. For the record, I'm Jennifer Roebuck, Deputy Director of Compliance for the department. Next, I'll cover some of the major tax types that impact our general fund and other funds. First up, we have sales and use taxes, which comprise the largest revenue category in our state. Sales and use taxes were enacted in Nevada in 1955 at a rate of 2%, and the rate is still 2%. In fiscal year '22, the department distributed $1.6 billion to the general fund. The sales tax rates that customers see are higher because today's tax rates encompass other components, which I'll cover shortly. Sales tax is imposed on retailers for the privilege of selling property at retail. The sales tax rate is based on the county in which a sale occurs and is applied to the gross receipts from retail sales. Use tax is the counterpart of sales tax. Both tax rates are equivalent and county-based. Use tax is imposed on the property purchased from a retailer where sales tax was not paid. For example, consider a purchase that was delivered to a customer in Nevada from a non-Nevada retailer who's located outside of our state. If the customer didn't pay Nevada sales tax, the customer would pay the state directly, and this would be use tax. This slide gives a high-level overview of the base tax rate for Nevada, which is 6.85%. It's made up of the 2% sales tax, which goes to the state general fund, the 2.6% local school support tax, the 0.5% basic city-county relief tax, and the 1.75% supplemental city-county relief tax. The last component that makes up the sales tax rate is the local option tax. Most of the counties have additional components in their sales tax rates for a variety of initiatives. This slide includes those components as well as when the rate was imposed. The last rate increase was Clark County, effective January 1st, 2020. Briefly, Washoe County was the highest sales tax rate in the state, but Clark County's last rate increase put them back in the lead. This sales tax map is a visual representation of our state and the various county sales tax rates. You might have seen this one already. Next, I'll dig into the components that distribute to all Nevada counties a bit more. The local school support tax is 2.6%. The tax was distributed to the state distributive school fund until July 1st, 2021, when Senate Bill 543 required the distributions to go to the state education fund. One distinguishing feature of this tax is the distribution is based on the reporting business's locations. The tax is distributed to the school district in which the reporting business is located. If a reporting business is located out of state, the local school support tax distributes to the state education fund. In fiscal year '21, the school districts received a total of $1.7 billion, and in fiscal year '22, they exceeded $2 billion from the local school support tax. The basic city-county relief tax is 0.5%. In-state sales are distributed to counties where the sales or deliveries are made. Out-of-state sales are distributed based upon the population ratio through the Consolidated Tax Program to the local governments. The Consolidated Tax Program combines tax revenues, including this one, the Supplemental City-County Relief Tax, and several excise taxes into the one C tax account for distribution. In fiscal year '21, the basic city-county relief tax transferred to the C tax account was $330 million, and the fiscal year '22, the transfer was $391 million. This slide is a supplemental city-county relief, which is 1.75%. The collected revenue is distributed through the C tax account by way of a formula. Some counties receive a guaranteed distribution, and the balance is allocated to the rest of the counties based on the distribution formula. In fiscal year '22, the total supplemental city-county relief distributed to local governments was $1.37 billion, which was up from the $1.16 billion in fiscal year '21. Finally, this slide gives additional details about the local option, which makes up the tax rates above the 6.85%. The counties have the option to increase their sales and use tax rates for specific purposes by ordinance. For example, above the 6.85% tax rate, Carson City has 4 additional tax components to fund public roads, open space, V&T railroad bonds, and infrastructure. The combined components make up the 7.6% sales and use tax rate in Carson City. A STAR bond, or Sales Tax Anticipated Revenue Bond, is a way for local governments to finance special projects. These special projects must be located within tourism improvement districts. and there are unique rules for the distribution of the sales and use taxes which are generated there. There are currently 4 of these districts in Washoe and 3 in Clark County. A tourism improvement district has special boundaries which is created by an ordinance. It's essentially an area where development's going to be built. NRS 271A.120 states that once a municipality has adopted an ordinance to create the tourism improvement district, they may issue special obligation bonds to finance projects for the benefit of the district. The bonds are secured by a pledge of up to 75% of the sales tax revenues generated within the district for a maximum of 20 years. The Department of Taxation remits the pledged taxes back to the municipality that has adopted the ordinance. The municipality uses the funds to make the payments on their bonds and pay other expenses related to the district. At the end of each fiscal year, the municipality must return any money that hasn't been spent to the department. That money is then distributed to the county and its local governments through the normal distribution routes. Modified business tax is imposed each quarter on the gross wages reported by businesses. The category of businesses that drive the tax rate and include, the category of business drives the tax rate and includes general businesses, financial institutions, and entities subject to net proceeds of minerals. The general business tax rate is presently 1.378% and is imposed on the reported gross wages less a deduction for qualified health benefits paid by the employer above a $50,000 threshold per calendar quarter. The rate for financial institutions and entities subject to net proceeds of minerals tax is 1.853% on gross wages with a deduction for qualified health benefits paid by the employer. The modified business tax total distribution in fiscal year 22 was $756 million, which is up from the $591 million in fiscal year 21. This tax is distributed to the state general fund. A little more on a modified business tax. Modified business tax was enacted in 2003, and the tax rates, deductions, and credits have evolved as a result of various amendments through 2021. In September 22, the modified business tax rate reduction determination was completed per NRS 360.203, which resulted in a rate reduction effective July 1st, 2023. Future rate reduction calculations won't be necessary as the rates have reached the bottom per NRS 360.203. In May 2021, the tax rate was reduced from 1.475 to 1.378% retroactively as a result of litigation. The court ruling required the department to issue refunds with interest to taxpayers for the overpayments during fiscal years 20 and 21. The commerce tax is imposed on each entity engaged in business in the state whose gross revenue exceeds $4 million. The tax rate is based upon the industry that the business is primarily engaged in. In fiscal year 22, the department distributed $282 million to the state general fund. Businesses are allowed a credit against their modified business tax for up to 50% of the commerce tax amount that they had paid. In fiscal year 21, businesses claimed $43 million in commerce tax credits against modified business tax due, and in fiscal year 22, they claimed $47.8 million. Commerce tax was enacted in the 2015 legislative session. At that time, all businesses with gross revenue in Nevada were required to file a return. By 2019, there were 594,605 open commerce tax accounts. Senate Bill 497 eliminated the filing requirement for those with less than $4 million in gross revenue. Since then, accounts are being closed, so that number of open accounts is less than half of what it was in 2019. In 2022, 14,404 returns were filed. And now I'll pass the presentation to Chief Deputy Yvonne Navarez-Goodson.
Thank you, Madam Chair. For the record, Yvonne Navarez-Goodson, Chief Deputy for the Department of Taxation. We're going to move through another couple of tax types, and if you will indulge us, we're going to bounce between Deputy Director Mitchell and myself for the next few tax types. First on our list is our insurance premium tax. The insurance premium tax represents a tax imposed at a rate of 3.5% on insurers which transact business in the state of Nevada, except for risk retention groups with a rate of 2%. The tax is assessed upon net direct premiums and net direct considerations written. The premium tax is due on March 15th of each year on premiums written in the prior calendar year. Insurers who are required to pay a tax of at least $2,000 on the preceding calendar year must pay quarterly tax payments based on actual net direct premiums and net direct considerations written for the current reporting quarter. The department distributed approximately $496.13 million to the state general fund in fiscal year 22, which represents an increase in gross revenue of approximately 5.16% over fiscal year 21. Next slide. The next tax type is our live entertainment tax for non-gaming establishments. There are two agencies that collect live entertainment tax in the state of Nevada: the Gaming Control Board, which collects live entertainment tax at gaming establishments, and the Department of Taxation, which collects the live entertainment tax for events and activities which occur at facilities other than gaming establishments. Live entertainment tax is collected from owners and operators of facilities where live entertainment is provided and who collect those receipts. The tax rate is 9% of the admission charge to a facility that provides the live entertainment in a venue or a facility with an occupancy of 200 or more, and 9% on escort services. The live entertainment tax does not apply to amounts paid for food, refreshments, or merchandise unless those purchases are required to enter the facility for the live entertainment. The funding is distributed to the general fund except for the $150,000 of annual distribution to the Nevada Arts Council. This tax is due upon the sale of the live entertainment ticket. As expected, the state experienced a significant decline in LET during the fiscal year 21 as a result of the pandemic. However, this tax is far exceeding revenues experienced even before the pandemic. The department received nearly $40 million in fiscal year 22, and if we look back to pre-pandemic revenue for this tax, we received approximately $19.16 million in fiscal year 20 and $25.8 million in fiscal year 19. The most recent change to the live entertainment tax was an amendment in SB 367 during the 2021 legislative session, which exempted live entertainment that is provided by or for the benefit of a governmental entity. With that, Madam Chair, I'm going to refer to my Deputy Mitchell. Thank you. Not my deputy, the deputy.
Thank you, Madam Chair. Jeff Mitchell, for the record, Deputy Director of Local Government Services. I'm going to speak to a couple of other taxes. First is the real property transfer tax. This was enacted in 1967. Tax attributable to the RPTT, as we often refer it to, was $253.6 million in FY22, an increase over the roughly $191 million attributable to this tax in FY21, which is an increase of about 32.7%. The rate established by this tax is $1.95 on each $500 in value for the transfer of real property. In Churchill and Washoe counties, the rate is $2.05, and Clark County, the rate is $2.55. The revenue is collected by the county recorders, and the distribution of this tax, $1.30 goes to the state general fund, 55 cents is distributed to the counties through the C-tax, the consolidated tax, and 10 cents is distributed to the account for low-income housing. Churchill and Washoe counties distribute the additional 10 cents of their rate pardon me, and Clark County distributes the additional 60 cents to the school district. Next up, I will visit about the net proceeds of minerals tax. The net proceeds, I skipped a chart there. I apologize. This chart just basically shows where the real property transfer tax comes from. The majority of the tax is generated within Clark County. Next up is the net proceeds of minerals. The net proceeds of minerals is calculated on the mining operations gross yield minus certain allowable deductions, which results in the net proceeds, and then it's times the tax rate. The tax rate is a little bit complicated. The ceiling of the tax rate is 5% with the floor of 2%. And depending on the ratio between the net proceeds and the gross proceeds, it's on a sliding scale between that 2 and 5%. The floor, in addition to the 2%, can also be the local, the local county property tax rate at which that mine is located. The department determines the tax on the net proceeds pursuant to NRS 362. Producers report the annual gross yield on each separate extractive operation, as well as the expenses related to the extraction, processing, transportation, and marketing of the mineral. Next slide. This slide gives a little bit more detail on the tax rate, which I was just visiting about there. There are approximately 103 net proceeds operators currently reporting to taxation, as well as 388 royalty reporters. This next slide shows a chart on which minerals most of the net proceeds are generated from. As you can see, most of the net proceed of minerals tax comes from gold and silver at 89.41%. The distribution of the net proceeds of minerals for fiscal year 2022 was approximately $174 million, where the general fund received $71 million, local governments received $96.5 million, and $6.4 million was distributed to the state debt service fund. Due to the passing of Senate Bill 3 from the 31st special session, currently operators make a prepayment on the general fund portion of their tax rate. We'll now go away from our major tax types into some other tax types. First, I will speak to cigarette and other tobacco products tax. The cigarette tax was originally acted in 1947 legislative session. The tax rate is 90 mils per cigarette, and other tobacco products is 30% of the manufacturer's wholesale price. The distribution of this tax is 5 mils per cigarette to eligible local governments through the C-tax, the Consolidated Tax Distribution, and 85 mils per cigarette to the State General Fund, less the administrative fee determined by the legislative appropriation that funds enforcement efforts for the department. Other tobacco products are distributed to the State General Fund. Assembly Bill 535 of the 2019 legislative session revised the wholesale cigarette dealer licensing fee and established licensing fees for cigarette manufacturers, wholesale dealers of other tobacco products, and tobacco retailers. The bill was effective October 2019, where the licensing portion was effective January 1st, 2020. In the 2019 legislative session, there was also Senate Bill 263. Vapor products and alternative nicotine products were added to the definition of other tobacco products. This includes electronic cigarettes, cigars, cigarillos, pipes, hookahs, vape pens, and similar products and components. The effective date of that bill was January 1st, 2020. To give an overview of the revenue, the other tobacco products saw an increase from fiscal year 2021 of 3.4 million. This is a 10.57% increase. Taxes collected for the cigarette tax were 162.5 million in 2021 and decreased to 153.5 million in FY22. I'll next go over liquor tax. This tax was originally acted in 1935 as a stamp tax. Liquor tax rates are $3.60 per gallon over 20% alcohol content by volume. Then over 14% to 22% alcohol content by volume is taxed at $1.30 per gallon. And then alcohol content between 0.5% to 14% is 75 cents per gallon. Beer is at 16 cents per gallon. Total taxes and fees and fines for fiscal year 2022 were approximately $56.5 million, where $50.39 million was distributed to this general fund and $4.6 million to local governments, with the remaining $1.47 million to the liquor program account for victims of domestic violence and community and juvenile justice programs. With that, I'm going to take a drink of water and turn the time back to Deputy Director Yvonne.
Thank you, Madam Chair. For the record, again, Chief Deputy Director Yvonne Navarez-Goodson. We were going to touch base on the cannabis taxes, but in the interest of time, our colleague, Director Klimas from the CCB, did a great overview of our cannabis taxes. One thing I just wanted to clarify for your sake is that the imposition of the wholesale cannabis tax is imposed solely on the cultivation facility and is levied only on the first transfer or sale of cannabis, and includes all transactions, not just arm's length transactions. Arm's length transactions, however, become relevant when the department determines the fair market value of wholesale cannabis. And again, to reiterate the comments of our colleague at the Cannabis Compliance Board, the department does appreciate and rely heavily upon the tremendous work of CCB and our relationship to be able to accurately and properly carry out our responsibilities as it relates to taxation, which does include our determination of fair market value. Also, in the interest of time, I'll move really quickly here as our director gave a very good overview of the gold and silver excise tax that was imposed in 2021. As a result of that enactment in AB 495, which has been codified in NRS Chapter 363D of NRS, the imposition of the excise tax on the businesses that are engaged in extracting gold and silver in Nevada with gross revenues exceeding $20 million. Those tax rates change depending on the amount of taxable gross revenue. Up to $150 million, the tax rate is 0.75%, and it's 1.1% of all gross revenue that's in excess of the $150 million. The GSET applies to each calendar year, and these taxes are reported on April 1st for the immediately preceding year. In fiscal year 22, the department collected approximately $36.9 million from the gold and silver excise tax for the first taxable year in 2021. Next slide. Our next tax is our lodging tax. Lodging taxes are imposed on the gross receipts from the rental of transient lodging. These taxes are remitted to local governments, and certain percentages are distributed to the Department of Taxation to then be distributed to the Tourism Promotion Fund and the State Education Fund. The county boards of commissioners are responsible for the imposition and collection of the lodging tax, while the Department of Taxation records and transfers the revenue to the appropriate state budget accounts. There are 3 rates imposed for the distribution to the state. The first is a 1% rate on gross receipts in a county with a population less than 700,000. The second is a rate of 2% of the gross receipts in a county with a population of 700,000 or more. And the third is an additional tax of 3% of the gross receipts in a county whose population is greater than 300,000. Next slide. The distribution under our lodging tax includes various amounts. In counties with a population of 700,000 or more, there is 3/8 of 1% that is distributed to the state to fund the promotion of tourism. The remaining 5/8 of 1% is distributed by the county treasurer to the county school districts for capital projects. In counties with a population of less than 700,000, 3/8 of 1% is distributed to the state to fund the promotion of tourism. The remaining 5/8 of 1% must be deposited with the County Fair and Recreation Board, and if there is no such board in the county, it goes to the Board of County Commissioners to be used as advertising resources in the county related to tourism. The additional 3% tax in counties whose population is greater than 300,000 is then remitted to the State Education Fund. Next slide. Previously, we've been discussing the imposition of various tax types, but now we're going to transition to a few of the fees that the department administers. State law imposes a fee of 10% on the lease charge of the short-term lease of passenger vehicles. 2 counties also impose an additional fee. Washoe County imposes a fee of 2% on the lease charge, with a 0.25% of that amount distributed to the Department of Taxation for its collection. Clark County also imposes a fee of 2% on the lease amount, with 0.1% of this amount given to the department. The revenue from these fees is distributed to the State General Fund and also to Washoe and Clark counties. And as our director mentioned at the outset of the presentation, the peer-to-peer car sharing program is taxed similarly to this short-term rental on lease. All right. And our next tax type here is our transportation connection tax. The legislature created this tax in 2015 to impose an excise tax on the connection of a passenger in Nevada by a transportation network company, an autonomous vehicle network company, a common motor carrier of passengers, or a taxi cab at a rate of 3% of the total fare charged on the transportation. These taxes are imposed on the use of a digital network, software application service, dispatch center, or dispatch center to connect a passenger to the driver, vehicle, motor carrier, or taxi cab. This tax is due and payable monthly. The first $5 million of each biennium is distributed to the Highway Fund, with the remaining distributed to the State General Fund. I'll now defer back to Deputy Director Mitchell for the remainder of our tax types.
Thank you, Jeff Mitchell, for the record. First, I'd like to discuss the bank excise tax. This tax was enacted in 2003 legislative session. It is imposed on each bank at the rate of $1,750 for each branch in excess of one maintained in any county on the first day of each calendar year. The distribution is straight to the State General Fund. Next fee that I would like to discuss is the tire fee. This is a fee imposed on the retail sale of a new tire at the rate of $1 per tire. The fee is collected from the purchaser by the seller at the same time of the sale, in addition to any applicable sales tax. 95% of the fee is remitted to the Department of Taxation, and 5% is retained by the seller to cover their related administrative costs. The revenue collected by the department is deposited for credit to the Solid Waste Management account in the State General Fund, and the State Controller distributes quarterly as follows. 0.5% to the Department of Taxation, 44.5% to the State Department of Conservation and Natural Resources, and 30% to the Clark County District Board of Health, and 25% to the Washoe County District Board of Health. The exhibition facility fee is a $5,000 annual fee, or if alternatively it is paid quarterly, the fee is equal to the number of businesses without a state business license taking part in each exhibition, multiplied by the number of days on which the exhibition is held, multiplied by $1.25. I will speak briefly on centrally assessed property. Centrally assessed property is a property tax. The Department of Taxation values the assessment on this property. It collects and then distributes the tax out to the local county governments, as well as to other funds where it is where it resides. The type of property that you can think of centrally assessed is property that crosses interstate or intercounty lines. This would be airlines, railroads, utility companies such as power companies, and so forth. And lastly, the locally assessed property section within the Department of Taxation is we oversee and we monitor the quality of assessments performed by county assessors. Department staff appraisers conduct performance audits and appraisals, a selected sample of appraisals within counties on a rotational basis. And we report those findings to the Nevada Tax Commission in the form of a ratio study. This ratio study provides a statistical analysis of the quality of assessments that are being performed and aids the tax commission in their duty of providing equity and making sure that assessments are being done as they should throughout the state. And with that, I believe we're ready for questions.
Thank you so much, Director and Deputy Executive Directors, for your presentation. It's much appreciated. We do have a few questions, and I know you guys have another presentation to get to, so we will try to get through that pretty quickly. Let's start with Assemblyman Nguyen.
Thank you, Chair, for amazing presentation. Thank you all for just going through that. I know that's a lot of information, so thank you, everyone. I just have a question regarding things that are created more than 20 years ago that is based on a number versus a percentage, right? So I know a lot of the taxes are based on a percentage, but for the ones that were created couple of decades ago that set on amounts, when obviously that amount back then is different than that amount now. Are there any thoughts on those things? Was there in terms of adjusting with the times? So I guess that's much more of a technical question, and that's something that is done legislatively, so.
Madam Chair, through you to Assemblyman Nguyen. Shelley Hughes for the record. Yes, many of that is in statute and done legislatively, so we do not have the authority to adjust any of those numbers. And we typically do not set tax policy. This body does that, so we are unable to really adjust those numbers ourselves, but are glad to implement anything that you adjust.
Just a quick follow-up, Chair. Oh, thank you. Is there a list that I can just have? I don't know if it was all listed here, but is it all listed here that all the one that has a number was all presented today?
Madam Chair, through you to Assemblyman Nguyen. Shelley Hughes for the record. I think we have everything included there, but if we don't, we can provide you a list.
Thank you very much. Thank you, Chair.
Thank you so much. Also, you guys can go directly to the member asking the question. I'm completely okay with that. We'll go to Assemblyman Gray.
Thank you, Madam Chair. Just a quick question. How many guaranteed counties are still left in the state?
Assemblyman Gray, this is Shelley Hughes for the record. We had this question earlier today, so I will defer to your fiscal team. Michael Nakamoto could answer that for you.
For the record, Madam Chair, Assemblyman Gray, Michael Nakamoto with the Fiscal Analysis Division. There are currently 6 guaranteed counties: Esmeralda, Lander, Lincoln, Mineral, Pershing, and White Pine, according to the information that we have obtained from the department.
And if I may just jump on there to just from clarification for everybody else, what is a guaranteed county?
Shelley Hughes for the record. So a guaranteed county is a county that would receive a guaranteed amount of funds from sales tax distributions. Typically, these are counties that are volatile in their revenues, and so they become a guaranteed county. If they make lower, their sales tax revenue is lower than their guaranteed amount, they still get their guaranteed amount. However, if their revenue is higher, they still get the guaranteed amount. So typically, these counties will not come off the guaranteed list because of the volatility of their revenue. But occasionally, we do get requests to come off the guaranteed list. And once they're off the list, they cannot go back onto that list.
Thank you so much. We will move to Vice Chair Constant.
Thank you, Madam Chair, and thank you for this presentation on top of the last presentation we had. This is just so incredibly helpful to put things together. But my question's a little off from that. You mentioned you have 413 positions. Are they all filled, or what's your vacancy rate?
Shelley Hughes for the record. We have 87 vacancies right now, so it's about a 21% vacancy rate.
Thank you so much. We'll go to former Chair, Assemblywoman Cohen.
Thank you, Chair, and thank you for the presentation. Following up on Assemblymember Nguyen's question, so when we talk about the difference between whether you're collecting a percentage or a set number, how does that impact the ability of your agency? How difficult does it make it in dealing with different programs that you might use, or is it costing the state more money because, this is a percentage versus, these are numbers versus percentages? Or does it not matter because it's all technical now anyway and it's all in programs?
Shelley Hughes for the record. That's a good question. I haven't really researched that, but we can look into that and give you an answer. I'm not sure if it does have an impact on our resources, depending on if it's a percentage or a set amount.
Okay, thank you.
I know we have Assemblywoman Anderson, but did anyone else have any questions? Okay, we will turn to Assemblywoman Anderson. I know you had a couple parts, a few questions. Good.
Feeling the love, Chair. Thank you. No, I do actually have a few questions. So, thank you. And I'm very similar to Vice Chair Constantine. I love this stuff. It's so much fun. So my first question has to do actually just with a clarification on slide 24 and 25 with the modified business tax. So if I'm understanding this correctly, the reduction is happening based upon current statute language because we've reached the level that it needs to be for that reduction. And this is based upon the language that was initially passed or might have been amended. Am I understanding that correctly, that it was already in statute to have this reduction of the modified business tax collection?
Shelley Hughes for the record. Yes, you have that correct.
Thank you. And then my next question has to do with something that I believe we've spoken of before. It comes under slide 39, and that has to do with the liquor tax fines and fees. I understand that it is done by the different volume and et cetera. However, what is not mentioned here is how is the making sure that no bad actors are out there. This is something I've spoken with other distributors about, and I'm just concerned about some of those, 87 vacancies have to do with those individuals who are researching those individuals who are not necessarily reporting correctly. So I guess that's a two-part question. The first is, how's the research being, or how are we making sure that this is in fact paid correctly? And the second is this a self-reporting area, or is this something that is done in a different fashion to make sure that the alcohol levels are in fact being fined correctly?
Shelley Hughes for the record. So we do have compliance investigators that work for the department. We have 5, and then we also have 1 chief. They do ensure that there's proper licensing. They look at invoices to make sure that taxes are paid, and they're operating within the 3-tiered system. And they do seize liquor if they find a violation.
Thank you, and it's my last question, I promise, Chair. Well, for tonight. This last one comes from slide 29, and it has to do with the live entertainment tax and how that is being utilized. So let's say that I were to buy a ticket, well, not through Ticketmaster, but maybe it is for the Taylor Swift concert. I will be taxed on that. However, if I were to buy a ticket to a Raiders game, would I be taxed on that due to this live entertainment tax the way that it is currently worded?
Shelley Hughes for the record. There is a sport exemption under the live entertainment tax, and if the home team is playing, the ticket will be exempt from the live entertainment tax.
Follow up, if I may. Is that okay?
Okay, well, let this be the last one.
Oh, I did say it was my last. I'm sorry. So what if it's two away teams that are playing? Would there continue to be a tax break, or would that also be taxed?
Shelley Hughes for the record, it would no longer qualify for the sport exemption, as long as the other requirements for the live entertainment tax is met.
Thank you, Chair, and thank you for the presentation and allowing me so many questions.
Thank you so much, Department of Taxation, for your presentation tonight. Next, we will open the meeting for public comment. We'll start with Las Vegas. And I don't believe there's anyone in Las Vegas, just give it a couple seconds, that would like to provide public comment. So we will move to Carson City. Anyone here this evening that would like to provide public comment? Okay, BPS, is there anyone on the phone who would like to provide public comment?
Chair, the public line is open and working, but we have no callers at this time.
Thank you so much. Are there any comments from the members before we adjourn? Okay, great. Well, just as a reminder, on next Tuesday, we will be in this room again, 3142 at 4 p.m., and we will be hearing from the Nevada Gaming Control Board. That concludes our meeting today.